Welcome again to the Melling Law YouTube channel, where we're starting off our video series about transfers on death. Today we are talking about specifically transferring real estate upon death. Now, in many states, actually not too many, it's not even a majority, but still in a good deal of states, you can do what's called a transfer on death deed. And what that does is it allows you to transfer your property upon death, but still make that transaction during your lifetime. For example, instead of transferring a deed to somebody to give them a piece of property during your lifetime and having them receive it during their lifetime, you just record what's called a transfer on death deed, meaning you've signed the property to them, but they have to present the county with a death certificate to be able to actually have that title vest to them and be able to have control over the property or to sell it or make improvements upon it. There are a lot of reasons why people do this. Number one is for tax purposes. If it's transferred upon death, they get that step up in basis. So it's as if they for tax reasons, if the recipient were to sell it later on, it's as if they had bought it for fair market value as of the date of your death, instead of if you were to gift it, they would have to pay taxes as if they had purchased it at whatever you received it at. So if that property has appreciated in value over the last several years, that's definitely a reason why you'd want to transfer it on death. But the other reason is because people don't want to go through the expense of doing a proper estate plan and setting up a trust, but they still want to avoid that probate process, which is the court supervised process to dispose of real estate and other types of assets. In these other states, these transfer on death deeds do have their place, but there are a lot of pitfalls with them as well. They don't quite work as intended all the time, and they do open people up to fraud. There's a whole bunch of other reasons why we don't like transfer on death deeds necessarily, and why Utah has not passed a transfer on death deed act. We have not authorized those within the state of Utah. So in Utah, a transfer on death is going to happen one of three ways. Either you have no estate plan in place, no will or anything, and you have property in your name. That transfer has to be to your heirs at law, because you don't have a will, so it's whoever by law is entitled to receive your property. That transfer has to be supervised by the courts through the probate process. That process can be pricey and takes at least 4 months and oftentimes more. So in Utah, if you have property and it's in your name and you don't have a will, that's what happens. Now, if you have the property in your name and you do have a will, the process to get the property into the names of your loved ones is exactly the same, the only difference being that the will dictates who receives that property instead of state law. So for state law, for example, if you are married and your spouse has passed away and all your children are still living, your children would receive equal shares of that. If your spouse is still living, but some of those children are not also children of your spouse, then there's a different formula for that to split some of that between your spouse, some of it between your children. When you have a will, you do away with all of that, and you are able to do what you want with a few exceptions, and we'll cover that in other videos. Finally, the third way that we transfer property, real estate, upon death in Utah is through a living trust. So rather than having the real estate in your name, the trust is going to be the thing that holds your real estate. It's held in the trust name. Now you can control that during your lifetime. You can sell that property through the trust as trustee. You can give the property back to yourself and sell it personally. Whatever that may be, you control it. But then after you've passed away, your trustee, your successor trustee, the person who you've said you want to manage your affairs, that person is going to be able to sign as trustee and sell without any court supervision whatsoever. So in Utah, what that process looks like is your successor trustee goes to a title company. They show the title company the trust. The title company reviews it, makes sure that it's compliant with their internal regulations and procedures, and as long as everything looks to be above board, they are able to draft a very simple policy to make sure that your trustee can just sign for that and sell the property. So transfers on death in Utah are happen one of those three ways: either through the probate court with the court's supervision according to state law, or if you have a will, still through the probate court, but it's distributed according to your wishes. And then finally through a living trust, which doesn't require any court supervision at all, and just has your successor trustee sign as if they were you, essentially. So thanks for watching. If you have any other questions about transfers on death or other estate planning questions, feel free to give us a call at any time.